On today's IP series, we will be discussing what happens when a contract elapses but one party continues to use the other party's intellectual property without their consent, permission, and authorization. And we know that we're talking about IP. This is very important. A few weeks ago, the Federal High Court sitting in Lagos, Nigeria, granted Mercy Johnson prayer by ordering or issuing an ex parte order restraining Virony Nigeria Limited from using images, videos, and audio content without her consent. Now, she filed a lawsuit claiming that the company breached the terms of their contract and infringed her intellectual property rights. So, today we'll be delving into the legal issues and implications surrounding contract terminations or expiration, breach of contract, and intellectual property infringement. IP, 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 IP. Welcome to IP series, home to all things IP related, where I give you the stories, tips, and implications to business and creative decision concerning your intangible assets with real life case study. I am your host, Rita Anri Chinda. Subscribe and turn on your notification so you don't miss an episode. Cheers, guys. Before I get into the details of this case, let me first clarify some basic concepts, such as what is a contract termination or expiration, what is a breach of contract, and what is intellectual property infringement. So, like my friends and grandpa, I call him grandpa anyways, like Telema will say, I'm going to start from the back, which is talking about IP infringement. IP infringement basically entails where someone who is not authorized to use another person's intellectual property right goes ahead to execute or expand on the exclusive rights that the law has given to an intellectual property owner within a certain jurisdiction or territory. For instance, in our case study based in Nigeria, you get. So IP rights in form of patent, trademark, copyright, trade secrets, industrial design, and plant variety, because we have a plant variety right in Act in Nigeria. And this kind of call when someone copies, sells, distributes, modifies, or displays your intellectual property without your consent. Now, each of these IPs have certain criteria or eligibility requirements that you have to pass in order for your work to be considered to be either a copyright document or whatever it is. It can also occur when someone uses your work. So if you're talking about copyright infringement now, the law provides that all licenses and assignment must be in writing. So if you don't have a written consent permission in form of an assignment or license, you're basically infringing. If you go ahead to commit acts that go against the law, you're also infringing. The law now has provisions to sort out or cure IP infringement in the digital age, such as the technological protective measures, the takedown proceeding, also giving the Nigerian Copyright Commission the right to do certain things to resolve certain dispute by creating the dispute resolution board. If it's a trademark where someone is trying to cause confusion or deceive consumers or pass off your good for unregistered trademarks, just so that there will be some sort of confusion as to the source or quality of the goods or services. This infringement can result in various sanctions such as injunctions, damages, accounts of profit, delivering up, or destruction of the goods. Next up is contract termination or expiration. In an instance where a contract naturally comes to an end according to its term, so you see the clause term. This contract will last for a term of 2 years, and once that happens, it expires. On the other hand, Contract termination is a phrase that should be used to refer to more premature end of a contract. For instance, if a contract can be terminated by mutual agreement, by performance, by impossibility, by frustration, by breach, or by operation of law. Then you have breach of contract, which describes the violation of a contractual obligations by one or more parties. A breach can occur when one party fails to perform or performs inadequately or performs late. If you also anticipate that the other party will not perform and then you communicate that intention to the other party, that is a breach of the contract. And then it can give rise to various remedies such as damages, specific performance, injunction, or rescission. Now that we have a clear understanding of this concept, let's look at how they relate to each other and to the Mercy Johnson's case. So, this case involves a dispute between Mercy Johnson, a popular Nollywood actress, and Virony Nigeria Limited, a leading manufacturer of household items and sanitary wares in Nigeria. So, sometime in September 2020, parties entered into a 2-year brand ambassador and endorsement deal where Mercy Johnson agreed to promote Virony's product using her images, the video, and audio content. And this contract terminated or elapsed in October 2022. That was last year, a year already. But Virony continued using Mercy Johnson's image, video, and audio content. And we know that when you're talking or dealing with celebrities, their image rights can be monetized with their consent. They can go into brand deals such as the one that Mercy Johnson did with Virony. They can also create merchandise with their brand name. They can trademark it. It also reminds me of the case of Omotola, when news broke out that she had trademark and everyone's going, oh, she can do that, stuff like that. But this case is centered more on copyright. Unfortunately, we do not have like an express provision on image right protection in Nigeria. However, what the law provides when it comes to photographs is that in the event of no contract, authorship shall reside with the initial author. However, when you're not talking about where a person takes a photograph for private or domestic use, the person who commissioned the work shall be deemed to have a non-exclusive license to exploit the commissioned work for non-commercial purposes and is entitled to restrain the publication, exhibition, broadcasting, communication, distribution, and making available of copies of the work to the public. Now, this contract was entered pre the passing of the 2022 Copyright Act. And under the old act, the principle that copyright shall vest in initial author, and the exceptions were if it was commissioned and not being so commissioned made in the course of author's employment shall belong in the first instance to the author unless otherwise stipulated in writing under the contract. So you see that there's so much emphasis on contracts. You need to document. Kind of reminds me of the ACM event I attended, and there was a session where they had a photographer come and give his view on IP. I didn't agree with some of the things he said, and it just made me realize that a lot of people don't really understand how IP applies to them when you're talking about the creative sector. Now, remember I was talking about how celebrities can monetize their images through licensing or creating merchandise or having an ambassador or endorsement deal. Now, If there's an unauthorized use of a person's image for advertisement which creates a false impression that such person has consented to the advert or endorsed the product, business, or service in question, you know, you might not have to look at what the justification for the legal profession protection of images in is within your territory, and what are the alternative measures for you in protecting your image right. I think the first one, again, like I mentioned, is um copyright, looking at it from the artistic angle. Then you will consider the trademark elements by registering your name or stage name or signature or whatever it is. Then you also need to consider the right to privacy and its use, right to privacy angle. You also need to consider the thoughts angle, law of thoughts angle, and the cyber law angles. So, in an event of where is a case of a celebrity or public figure, do we really have limits to their right to privacy? I think the case that usually comes to mind is in Naomi Campbell's case, though foreign. Passing off is another angle where someone can protect their goodwill and reputation by preventing a person from misrepresenting them to the public. So there are criteria that you may need to consider. So in all of this conversation, please endeavor to speak to your lawyer. Um, then there's the action for breach of confidence. When you're trying to protect certain information from getting into the public hands or whatever, or however the case may be, there are different alternative and measures that one can consider when you're talking about that. But I'm not going to delve on that because that's not like the main crux of our conversation. Well, our main conversation is focusing on breach of contracts, termination or expiration of a contract, and intellectual property rights. However, this case has raised some interesting questions, such as, can Mercy Johnson sue Virony for breach of contract and IP infringement? Does the expiration of the contract affect her right to her intellectual property? How can she enforce her rights and obtain the appropriate remedies in Nigeria? Now, in answering this question, we need to take into consideration first the jurisdiction and specific terms of the contract. I've not seen the contract, but based on publication, what I stated in my introduction are the things that transpired. Unfortunately, we do not have what is called the principle of non-cumul, which means that one may not allow an action in tort to be made by one contracting party against the other for compensation of damages arising from an act which constitutes a breach of their contract. That's not considered within our jurisdiction. However, this is not excluded from contractual liability, where people that are bound by a valid contract and the damage suffered by one of them results from non-performance or improper performance of a contractual obligation. Now, in jurisdiction where that occurs, Mercy Johnson may be able to sue Virony Nigeria for both breach of contract and intellectual property infringement, as long as she can prove the elements of each claim and avoid double recovery. Secondly, the expiration of the contract does not necessarily affect Mercy Johnson's right to her IP. Unless the contracts explicitly transfer the ownership of the IP to Virony, she remains the owner of the work. So when you're drafting your contract, especially when you are representing the brand, IP ownership is a very, very crucial topic that may lead to dispute, as we have seen. as the contract may grant the brand, which in this case is Virony, a license to use her IP for a limited period of time. But once that contract expires or elapses, that license also expires. And Virony has no right to continue using her IP without her consent, express consent, written consent. So therefore, Virony's use of her IP after the expiration of the contract may constitute both a breach of contract and an IP infringement. Reminds me of the Airtel case that was the judgment was given this year. Also reminds me of the Onyeka case with Iroko in TV. I think, yeah, there's always something where brands feel like they are in the right, or they just assume, oh, we don't have good enforcement laws, or we don't have good laws, or so IP doesn't really work in Nigeria, so we can basically go ahead using the IP. No, read the clause so you understand all these things, and then we don't have to. I mean, we need precedents, no doubt. We do need precedents, but it's very important that both parties get their lawyers to explain each clause to them, and everyone goes home happy. Thirdly, Mercy Johnson can enforce her rights and obtain the appropriate measures by filing a lawsuit at the Federal High Court in Nigeria. So the jurisdiction, or the court that has jurisdiction to hear IP related matters or disputes, is the Federal High Court. And depending on the jurisdiction, the nature of the claim, she may be able to obtain various remedies such as injunctions, damages, account of profit, delivery of, destroying the infringing property. I think the one I always smile when I say is payment of attorney's fees. I don't know why, but payment of attorney's fees and payment of the suits, payment for filing the suits itself. But one thing I have come to realize from this case is that this is a clear example of how IP law is evolving adapting in Nigeria. It also highlights the importance of protecting and enforcing IP rights and the potential risks and challenges of entering into contracts that involves IP rights. But yeah, I think it's a good start for me. I think when I saw it, I was really, really excited about it, and then I said, okay, if you've read the what's it called, if you read my LinkedIn post, you might find this a bit more insightful. So just to touch up on the remedies angle, an injunction to stop Virony from using her image is another way, as we saw from the ex parte order restraining Virony from doing so. Disclosing the origin and distribution network of the product and materials that use her images, damages for the loss of income, reputation, and goodwill that she suffered as a result of Virony's action. So please let me know if you are in support of what the courts came up with, or the court's decision. So imagine someone is like, oh, you've infringed on my work. How do you then prove that this person has infringed and that you own the IP and another party has used without your consent and authorization? Now, this would depend on the type of IP. You may also need to provide different types of evidence to support your claim. So let's say, okay, because this is a copyright litigation, let's say you need to show an original of the creative work in question, especially when you've complied with section 87, which talks about registration of work. You can reach out to the Copyright Commission to give you a certified true copy or an extract from the register that can be admissible in evidence in all proceeding without further proof or production of the original of the matter certified. Other sources of evidence that can be used to prove an IP infringement claim is proof of your IP registration certificate, applications or records, your IP portfolio such as your design works, trademark, contracts, your license agreements that relate to your IP, invoice receipts or financial statement that show that your IP revenue show your IP revenue or expensive, your marketing materials such as brochures, website, advertisement that feature your IP, the infringing products, material or activities of the other party, the sale, distribution, or online record of the other party that show that their use of your IP, the consumer survey, there's a need for that. I think that was used in the booking.com case, though a trademark case, but then that's an alternative. Reviews that indicates the confusion or harm caused by the other party's use of your IP, the expert opinions, analyses, or reports that compare or contrast your IP with the other party's use of your work. So with all of this is up, it's clear that proving IP infringement can be very complex and challenging process. It may require the assistance of a lawyer. No, may it does require the assistance of a lawyer, especially one who is versed in intellectual property or copyright or whatever type of IP dispute you may be having. So if you suspect that someone has infringed your IP, carry out your due diligence before you go about rambling that, oh, this person has infringed on my IP. Stuff like that. Take for instance, you are in Virony's shoes. What are the possible defenses you have against Mr. Johnson's claim of IP infringement? One, you can argue that the IP in question, that is the videos, the audios, her images, are not valid and not enforceable, and that it does not meet the legal requirements for protection, such as being original in a fixed or tangible format, irrespective of the quality. Secondly, fair dealing principle. You can claim that your use of the IP falls under the doctrine of fair dealing as provided under Section 20 of the Copyright Act, which includes that your use was non-commercial and it was done, or you used it for private purpose, to criticize, to do a report, to carry out a non-commercial research and private study, review something, but then the law now further provides that there are ways to determine whether the use of a work was actually a case of fair dealing. One, the purpose and character of the use of the images of Mercy Johnson, the audio, the videos, the nature of the work, the amount and substantiality of the portion. Oh my god. Of the portion used in relation to the work as a whole, and the effects of the use upon potential market or the value of the work. So the contract terminated a year ago. So within that timeline, what's the effect of the use upon potential market and value of the work? If the work was included, so that's it for fair dealing. But then there are other general exceptions that the law makes provision for under Section 20. So if you have the time, please guys, read it. Next is that you can argue that Virony can argue that they used the IP before the claimant obtained or registered their work, and that they have prior right to continue using the IP. Then there's the non-infringing use, where you prove that your use of the IP does not infringe the rights of Mercy Johnson, either because it falls within an exception or exclusion under intellectual property law, or because it does not meet the elements of infringement. See how technical it is and complex and also challenging. Then there's the licensing and consent aspect, where we already can show that they had valid license or permission from Mercy Johnson to use her images and that they comply with the terms. I think this one will not fly anyway, because it's obvious that October 2022, you guys didn't get that consent. Then there's the issue on statute of limitation, where um where the timeline for you to file a lawsuit against someone has expired, you know. And when you're talking about copyright related disputes, the statute of limitation for copyright infringement is 6 years from the date of the last infringement act. Now, the clock is always ticking when it comes to filing of lawsuits in Nigeria. And statute of limitation, though a fancy term, sets a timeline for when a case can be brought to court. If you snooze past the deadline, you will be blocked from seeking justice, and any recourse will be off the table. So don't dilly dally. What are the consequences of copyright infringement as provided under section 36 to 43? It's a long read, but please be patient and read it. Now, in the event of an unauthorized use of the original work, such as Mr. Johnson's images, videos, audios, etc., she is entitled to damages for loss of profit, injunction, and delivery of or any other available reliefs in corresponding proceedings concerning infringement of other proprietary rights. It's also important to note that the criminal penalties for such infringement can result in a fine ranging from 10,000 naira to 1 million naira or a prison term of up to 5 years. Not a good thing, right? Yeah. So let's work on or ensuring that we do the right thing when we're talking or dealing with intellectual property rights. What are some of the other actions that you can take to enforce your intellectual property rights? One, signing a cease and desist letter to the infringer demanding that they stop using your intellectual property and to remove or destroy any infringing material within a timeline. Second, you can file a complaint or lawsuit against the infringer, seeking an injunction, damages, or other available remedies within your jurisdiction. Thirdly, you can report the infringer to the platform or authority that hosts or regulates their activities, requesting them to take down or block the infringing content or accounts. That's in the event where the IP, looking at it from a digital standpoint. You can also negotiate a settlement or a license agreement with the infringer, allowing them to use your IP under certain terms and conditions. You know?
How else can you then protect your IP? Well, let's start with a couple of IP clauses that you may find in contracts. One, a clause that assigns ownership of any IP created by an employee in the course of their employment to the employer. So you see something like the employee agrees that any and all IP rights in any invention, blah 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 blah, belongs to blah blah blah. You know, a clause also grants a license to use the IP of one party by another party for specific purposes, duration, and territories such as the licensor hereby grants to the licensee a non-exclusive, non-transferable, revocable royalty, long. A clause that transfers the ownership of the IP from one party to another in exchange for consideration. So whenever you're talking about the contract, what Virony should have done, in the event where Virony the contract has said that the just was transferring ownership of the IP to Virony in exchange for royalties. You know, that was passed. So yeah, signing on a just hereby assigns sales transfer conveys to Virony all the rights, etc. etc. So then there's a non-disclosure or non-circumvention clause that can be included in employment agreements or brand ambassador endorsement deals, depending on what parties agree on. Then there's indemnity clauses as well.
What are the consequences or repercussions of violating someone's intellectual property rights? One, legal actions can be initiated, or commenced by the IP owner or licensee, and remedies such as injunction, damages, profit costs, and attorney's fee can be sought. You could be criminally prosecuted by the government, where you can receive punitive measures such as fines, imprisonment, seizure, destruction of the infringing material. There are lots of reputation and goodwill. Infringing parties risk tarnishing their reputation and goodwill. They could get negative publicity, consumer backlash, and loss of market share are some of the possible consequences. I think you find this a lot if you watch K drama. Please forgive me once again. Or if you watch foreign movies, you see this in full effect where a business is really concerned that their action could lead to them losing their reputation and goodwill. Then finally, loss of business opportunity. The infringing party risks losing business opportunities and their competitive urge, which may lead to the imposition of restrictions or bans on their product or services. Additionally, they might lose their licenses or contract. Do you agree? Yes, of course you do. But if you don't, send me an email to ipseriesinfo@gmail.com. As usual, I am always open to learning and taking corrections. Okay? In wrapping up, here are lessons for brands, celebrities, influencers on how to protect their intellectual property rights in a contract. First is document and register your IP, especially because in Nigeria we apply the first to file principle. Our IP system is the first to file principle. Then get an IP lawyer or law firm to review any contracts before you sign. Third, beware of the following in perpetuity: assigning of moral rights irrevocable. Fourthly, not including a properly drafted dispute resolution clause, especially now that we have an Arbitration and Mediation Act 2023 that was passed by the current president of Nigeria, President Tinubu. Not exploring good enforcement provisions such as reporting the infringer, not exploring anti-piracy measures such and border measures, cease and desist or filing of a lawsuit, lack of understanding on the concept of joint authorship, ownership of an IP, etc. Not meeting the eligibility requirement to ensure that you are able to claim ownership of the IP in question, not educating and putting out notices about the IP you own to deter or discourage infringers, not taking into consideration of the fact that IP is territorial in nature. You also need to be aware of defamation, passing off claim, impersonation claims under Section 2022 Sub 3 of the Cyber Crime Act. And thank you, listeners. Thank you, IP friends, for tuning in to IP series. If you enjoyed this episode on termination of contract, breach of contract, IP infringement, with a focus on the Mercy Johnson case, please subscribe to my podcast on any of the platforms you're currently listening onto right now. Until next time, this is Rita Awenrichinda signing off. Cheers, guys.